Hi everyone, this is Nahid and welcome to my video once again. Today I'll be trying to talk about international commercial agreements that we enter into off and on with counter parties from different countries. International agreements are the agreements that have been entered into parties uh, entered by the parties who are from different jurisdictions, different countries actually. What is very important in entering into an agreement with foreign countries is that we have to understand the legal system and legal provisions that may apply to the agreements. So this is why I'm trying to say something today about these international agreements. Uh, Agreement is based on contract, and the definition of contract is different in different countries. If you look at the civil countries, you will find a separate kind of definition of contract, and if you go for the common countries like UK, USA, Australia, also in Bangladesh, you will see a different kind of definition of contract. So this is the way the legal system, legal rules and regulations are different in different countries. But there are some very common provisions that in the modern era, the corporate bodies that keep in their agreements, like good faith provision, battle of forms provision, governing law, arbitration, and those very important things. But these are very critical and very complicated because you put a provision on choice of law. Suppose the choice of law you have kept is US law, but the thing is, none of the parties of the contract are connected with US laws. Then, although you choose a law, that law may not be applicable in dealing with the agreement. So this is the way. There are some matters that we have to keep in mind before we go for entering into an commercial agreement. So one of the first thing that we need to know is the legal system. Today I'll be focusing on the legal system of USA and what are the matters that we have to keep in mind before we enter into an agreement with the US. US has three kinds of courts in a federal level, at state level, and the trial courts. According to Article 3 of the US Constitution, the federal court is allowed to hear the cases on constitutional matters, federal laws, and some matters like citizen to citizen, like a citizen of one country, he wants to be a citizen of USA, and like that. And there are a lot of trial courts. There are a number of 94 trial courts in throughout the whole country. The states which are very small, less populous states have only one. Suppose Alaska has only one state court, and there are some other states which are very populous, like California, New York. They have multiple trial courts. There are also states courts, and there are some other courts like Court of International Trade, Court of Federal Claims, etc. Court of International Trade is very important in the sense that we are talking about international commercial agreements, and when we face any problem, any dispute with the US counterparty, then we might be forced to go to the Court of International Trade. Now come to the legal provisions that we keep in our agreements, in commercial agreements. Like if you enter into an agreement with the US counterparty, you might be familiar with a provision like good faith. Actually, good faith is a provision that international corporate bodies want to keep in the agreement, but in USA, UK, Australia, and some other commonwealth countries, you may not be forced or you may not be required, as the laws of those countries don't require you to put good faith clauses. But if you look at the civil countries like France, Germany, they may require you to put a clause on good faith. And if you look at the laws of Germany, BGB, uh, which governs the civil litigations, civil code actually of Germany. This law requires you to put a provision on good faith. So this is the way the good faith provisions differs in different jurisdictions. Another very important clause that you may require to put in your agreement is the battle of forms. So what is battle of form is when you enter into a contract with the foreign counterparty that and you want to purchase something from them. So the seller of the foreign seller will send you a format of contract dealing with all the matters of the agreement. There are a lot of clauses, lot of sections, and you go through all the sections and clauses, and oh, you actually don't always put your signature on the paper. You make some changes there, like you don't like the price, you need the price to be something less than they have sent you. And there are some provisions like time frame within, they want to send the goods within 3 months, but you need to get them within 1 month. So these are the provisions that you need to be changed. So you make your own format of contract and send the contract format back to the foreign counterparty. And this is the way the forms are given to this party and sending back to another party. This is known as the battle of forms. So battle of form is very important in the sense that to enter into a contract you need offer and acceptance. So this offer and acceptance through battle of forms differs according to the jurisdictions. Like if you talk about USA, the battle of forms is governed by the courts in such a way that when one puts some changes on the form and send it back to the other country, that is not the offer. That is not the acceptance, because you have put some changes on the offer and send it back. So this is taken granted as a counter offer by the courts of USA. If you look at the jurisdiction of UK, you will see that the courts will look at which one form has been given at last, and after that the acceptance took place, and the court will depend on the last format of the battle of form, and this is known as the last shot system in UK jurisdiction. If you look at the Australian jurisdiction, you'll find that the court will take consideration of the whole agreement procedure. The form is, one party has given a form, then another party has sent the format back to them, and this is the way the agreement takes place, and the court will look at the whole procedure. In this way, if you look at the civil law countries, you will find that when you put some changes on the format that you have received from the counterparty and you send it back after making some changes, that's a complete rejection. But if you look at the common law countries, we'll find that that's not a complete rejection, but the civil law countries will consider that as a complete rejection. So this is the way the battle of forms is very important. And it is also very important in the sense that the international agreements are not made within hours, within days. It takes time. The parties sit together, they negotiate on different terms and conditions, and through these negotiations they come to a point and they make the offer and acceptance and all these things, and the agreements become enforceable.